Have you ever come across an interesting article that you wanted to share? Chances are the content is copyright protected, which means the author or publisher of that material has the exclusive right to decide where and how their work may be used and on what terms. This protection exists to encourage the development of creative works whilst benefiting creators for the use of their content. Copyright laws affect people in virtually every country, and although they protect all types of print and digital content, you will find there are some exceptions. Knowing when and how copyright is applied can be challenging. Fortunately, thanks to a series of international treaties, most countries follow the same basic rules. For example, chances are, if you share copyrighted material in the course of doing your job, you probably need to get permission from the copyright holder. Contrarily, if you share that material for certain personal uses, you may not need permission. There are some common situations in which you may need permission from the copyright holder. These include emailing a published research report to co-workers, posting an article or report on your intranet, photocopying a newspaper article for a team meeting, or posting a news story about your company on your website. No matter where you are located, your country almost certainly has its own set of unique copyright rules and set of exceptions to the rights of copyright holders. So there may be times when you can copy and distribute published material without permission. There are also general exceptions that vary by country. The most familiar include fair dealing in the UK, Canada, and other Commonwealth countries, and fair use in the United States, Israel, and elsewhere. Licensing the use of copyrighted material is handled in many different ways around the world. Some countries charge a levy on equipment that can reproduce copyrighted materials. The money generated goes to pay royalties to copyright holders for the use of their content. In other countries such as Canada and the UK, the law allows for licenses that automatically cover many different publications of all copyright holders, but it is up to the content user to buy them. In the United States, licensing is completely voluntary for both those who use content and those who create it. In general, businesses and other organizations can choose to purchase an annual license for the rights to share content from many different works in many different ways, or they can secure pay-as-you-go permissions. Both options are available through collective licensing organizations. Many people confuse the concept of getting the rights to use someone's work with the act of crediting the author. Attribution is not a substitute for copyright permission. It is only sufficient when you use a relatively brief direct quotation. In fact, in most places, attribution is required in addition to obtaining a license to use copyrighted material. Respect for the intellectual property rights of others really does matter. Every day, businesses, universities, and organizations everywhere depend on information from trade journals, books, news sites, blogs, and so many other content sources. Respecting the copyrights of others ensures that the content you value most will be around for years to come. It's also the law. If you violate the rights of copyright holders, they can sue you and your organization for damages or to recoup lost profits. This can hurt you financially and damage your organization's reputation. And from an ethical perspective, respecting the rights of copyright holders is simply the right thing to do. It also helps ensure that your own work is respected by others. Navigating copyright laws in multiple countries is a challenge. If you are unsure of your responsibilities when it comes to using copyrighted material, ask your company's information professional or legal counsel for advice.